Now we're recording.
Okay. So chapter 2, criminal liability, the essence of a crime. Essence of the crime. This is criminal law. Anybody taking 111 criminal procedure? No? There was a time when I refused to teach both classes in the same semester. Criminal law, AJ 101, and criminal procedure, AJ 111, because the overlap. I could be talking about something in this class, and this is when we were on campus the whole day. The next class comes in, and it's the 111 class. I'm thinking, didn't I just say that? I was getting mixed up because they're so closely aligned. There's some differences. Criminal law talks about the law in general, the essence of a crime, things like that, what it takes to prosecute a crime. Criminal procedure, just that, from cops to the courts to the correction, and it's divided in 3 phases, and we get into a lot of detail. Then I teach criminal evidence 103. And evidence, this week, right now, we're talking a little bit about procedure. And so when I created the PowerPoint, I finished the lecture last night, I'm looking at it and I go, wait a minute, I think I'm talking about some of these things today. So anyway, if you have 103, 111, 102, there's gonna be similarities, but yet differences, if that makes sense. Okay, so criminal liability. Understanding the fundamental elements that constitute criminal conduct. We talked about that, where our laws come from, how a law becomes a law, the references of the law, whether it's natural, whether it's positive. Okay, we talked about those things. Now we're moving a step forward. How our legal system determines guilt. Okay, how do we reach the finding of guilt? We're going to talk a little bit about what happens in the courtroom. Actus reus, mens reus. Not so much strict liability, that's more in civil, but then concurrence. We're going to talk about those 3 sections: actus reus, mens reus, and concurrence, and how they impact criminal law. Okay, you're supposed to work. Maybe my battery's dead. All right, so this is how I hope to present the information, but knowing me, it helps if you put batteries in these things. I tend to stray, okay? I will stray away, but I do try to come back, and that's why I prepared this to keep me in line. We're going to talk about some criminal cases, some relevant, important cases, legal essence of the conduct, the actus reus and the mens reus, criminal act. We're going to break it down. We'll talk a little bit about liability, but not much, strict liability. That's usually industrial protection. If you have a curling iron, I know I use mine every day. Actually, I used to use a straightener. My beard was like down to here, and it got frizzy. So my wife said, use the straightener, and I put the straightener on like that, and it actually worked pretty good. Okay, so we'll talk about the straightener since I have used that. What are some of the companies that make those things? Anybody? No? There's companies. We'll go with Revlon. I know what Revlon is. So Revlon's a huge company. They make my straightener for my beard. One morning, I'm using my straightener. I plug it in, and I go to use it, and the little plates in there, I told you I know how. The plates melt. They got so hot they melted, and it stuck to my beard. And so I know I'm making up a story here. It didn't really happen. And so I had to cut my beard off. And there's this freaking curling iron stuck to my beard because it overheated. So I unplug it. I do some research because I'm good at that. And I found out I'm not the only one that's had problems with this particular model. So I contact the attorney that's representing these other people that have also had similar problems. And they file what's called a class action. Okay? We get approved by a judge to consider this as a class action, and we move up through the courts, through the ranks. At some point, Revlon is going to show up with their representatives, their attorneys, and argue. But when they're found guilty and they're guilty, there's no need, here's the key, to establish intent. Okay, like in a criminal law, you gotta have intent. You gotta have that mens rea, but not in strict liability. You only have to show that it happened and that the person producing this item was at fault. They're the ones that produced it. They should have known. Okay? That's strict liability. Really briefly, there's a few more things to talk about, but we're not gonna get into it. We're not really focusing on strict liability. You just need to know what it is. All right, so we're gonna talk about the actus reus, the mens reus, and the concurrence. That's really what we're gonna be focusing on. Criminal cases, an accused is charged with violating some kind of a rule. The prosecution, this is the government, they must show evidence that each element of a crime, we gotta check them all, that this defendant met each element of a crime. And just for now, just know there may be 3 or 4 elements to each crime. Intent is one. They gotta show that this was an intentional act. Overcome the presumption of innocence and prove guilt beyond a reasonable doubt. My lecture last night, boy did I hammer the different levels of guilt. Okay, different levels of guilt. Beyond a reasonable doubt is the highest level of certainty. We know this person's guilty because these 12 jurors said so. There's no doubt. Sometimes they do get it wrong. But as far as the court goes, the legal, we don't care because these 12 people said this person was guilty. Highest level of certainty. There's about 4 or 5. I'm gonna run them down to you. They're not gonna be in here, I think, but I'm gonna tell you anyway. The next level, okay, is probable cause. Probable cause. Levels of certainty. Beyond a reasonable doubt. Probable cause. Reasonable suspicion. Preponderance. And then a hunch. A hunch. Preponderance is the 4th item of certainty I listed. Here's the scary part. For a civil case like that strict liability we were talking about, all the court needs is preponderance. I was a hearing officer. I sat down, adjudicated a lot, like thousands of 115s, disciplinary actions against inmates. And when I found them guilty, all I had to have is preponderance. What's preponderance then? Somebody give it a shot. What is preponderance? We got beyond a doubt, beyond a reasonable doubt. Right? Probable cause, reasonable suspicion. So what's preponderance? How much guilt? We'll go with 100%, right? 100% up here. So what percentage do we need to prove preponderance? Take a stab at it. Nobody. Says you move, so I'm gonna get you. Give me a number. What do you think? What would you be happy with? That's tough. I don't know. Anybody, help her. 75. 55. 30, 50. The books, anything you're gonna read, they're gonna say preponderance is 51%. 51%. That's not quite true, you're close. 51%, that's what the textbooks want you to believe. But here's the reality. Preponderance is you believe it just a little more than you don't. And the way I like to show this, imagine the scales of justice, right? The scales, perfectly balanced. Equal amounts of sand on each side. I mean, this thing is right at 0, perfectly balanced. Take a grain of sand and put it on this side. Just enough to tip it. That's preponderance. And that's scary. Preponderance scares the hell out of me. You just gotta believe it a little bit more than you don't. Constitutional protections, these are the things that come in. The right against self-incrimination. You cannot force someone to talk to you, okay, as an officer of the law. Can't do it. Right to confront, cross-examine witnesses, and court instructions to the jury, and there's a few others in there too. If you look at the Miranda rights, okay, it all came from not affording a defendant their due process rights. And Miranda was a piece of crap guy, but he got off on it. They got him later for some other stuff. But he wasn't English speaking. The officers read him something in English and said, yeah, he understood his right. You can't do that. Because of that, we also have an acknowledgement form now. after reading the rights, you have to get an acknowledgement. If they're willing to sign, they can, the defendant. Yes, officer read my rights, I understand the way they were read, I get it. Most of the times they're gonna tell you to take a hike. So there's a little box. Defendant chose not to sign, and then you sign on their behalf. Okay, but there is an acknowledgement component to it. Two fundamental elements, here they are. And there is a third one, but actus reus, the criminal act, action, okay, something had to happen. It must be voluntary. It must be a commission or even an omission in some cases, or physical manifestation of a crime. Criminal mind, culpable mental state. Key word here is culpable. You have to be in a frame of mind that you understand what you were doing. Otherwise, you could plead insanity. Also known as a scienter and ranges from intent to negligence. There's degrees of mens rea. How many times you may have heard somebody say, well, yeah, I did it, but I didn't know that was going to happen. Right? Yeah, I pulled the trigger. I aimed it in his direction, but I didn't think he was going to die. Because in the movies, they always get up again for part 2 of that Witness movie. These kids are be back, you watch. All right, so they come back. Doesn't really happen. It doesn't happen. So, ranges from intent to negligence. You could still be held criminally liable for being negligent. You didn't intend for the outcome, but because of your actions, it did happen. And we're going to talk about it a little bit more. So you got actus reus. Okay, you got the action. Somebody did something. Then you have the criminal intent. Separately, they mean nothing. Okay, you got to bring them together. That's the concurrence part. Where these two come together, think of a Venn diagram, and they overlap. That's your concurrence right there. That's what the district attorneys have to prove, the concurrence. Yes, they committed the act. Yes, they knew what they were doing, and here is the result of that action. That would be the concurrence. Questions? Does it make sense? Yeah, we're getting it, right? Okay, so the criminal act, let's break it down. It has to be voluntary, we said that. The act must be a product of the defendant's conscious will, not a reflexive or unconscious behavior. Or it cannot be under duress. Okay, it has to be voluntary. Thoughts alone cannot constitute a crime. There must be some bodily movement or physical manifestation. If thoughts alone were a crime, I'd still be locked up for some of the ones I had against my ex-wife. I even had a plan. I was a lieutenant at the time, my sergeant. He was going through an ugly divorce. Mine was settled, but she kept coming back for more money. And so we would talk in our office, and we would come up with the most devious plans for retribution. We were going to get even with these women. And we talked them jokingly. We would never do anything. But if thoughts alone were a crime, boy, we would both still be silly somewhere, locked up. So no, thoughts alone are not a crime. Prohibited, the act must violate a law that defines it as criminal conduct. And what's not here also is only a human can be held accountable for criminal conduct. Somebody else gets, what if you have a trained monkey and the monkey's the one that shot the person? Then the monkey's the one that's gonna go to court. No! It's the person who trained the monkey. Only the human, only a human being can be charged with a criminal action. Okay? Thinking is not doing, as I just told you a little while ago. A man who thinks about killing his wife. Honestly, I didn't write this one. A man who thinks about killing his wife, plans the details, cannot be prosecuted if she dies in an unrelated car accident that he had nothing to do with. That's called getting away with it. Made it look like it. No. In all seriousness, guys, this was a long time ago, 1996, 7, something like that. 1996, 7. I became lieutenant in 94. That's a long time ago. You're thinking, God, he's still here. Yeah, I'm still here. Okay, so 1994. I'm thinking about all these things that me and my partner Jeffries, that we could do to our ex-wives. By some grace of God, because it would be a miracle, something did happen to them. And not dead, but something seriously, they got injured. They can't come back and charge us with a crime because we openly discussed it. We had nothing to do with it. They have to prove a link, it's called a link of causation, that because of something we may have thought of and did, resulted in that action. So thoughts alone are not a crime. It says being is not doing. To be something is not a crime, but to do something, it may be. Okay, the law punishes actions, not status or identity. Anybody, you could read the rest of this. Anybody know where we're getting at here? What we're talking about? Let's see. Being alcoholic? No. Being addicted to drugs? No. Okay, I'm thinking more gang activity. You're on the gang task force. You're out patrolling. You know this person is the shot caller for this gang. You see him hanging out right out here. You know these things to be true, but you don't have any cause to make an arrest or even question the individual. Just because they are who they are the numero uno, the shot caller, doesn't mean you can charge them with a crime. You have to prove an action. Does that help summarize what they're telling you here? Hopefully. Voluntary acts. Okay, the law of most jurisdictions specify that a person's actions must be voluntary. Okay, they have to be. Let's look at the voluntary side first. May create criminal liability. Conscious bodily movements, deliberate choices, actions taken while intoxicated if it's voluntary. I've been in court where somebody was drunk driving, got in an accident, caused some significant injuries. Told the judge it wasn't their fault because they were drunk. Judge says, did somebody force you to drink? Oh no, I was at a party. That's a voluntary action. You put yourself in that status of being drunk, you're going to be held liable for your actions because you put yourself in that position. That's cut and dry. But what about medication? If I take some medication, some Vicodins or something that's pretty strong, and I'm kind of out of it, and I get behind the wheel, and I cause an accident, am I guilty of a crime? Yes. Absolutely. Yeah, absolutely. And they tell you right on the bottle, don't do that. Right?
Do you have a pencil sharpener?
I can't hear you.
Do you have a pencil sharpener?
No, not here. Yeah.
You did.
Got a pencil you could use. Make sure I get this my favorite one.
I mean, I already have one. It's just that.
Oh no, but I don't have a sharpener.
No.
I used to carry one. That's how far back we go. When students were still using pencils, because we're using those Scantrons, if you remember that. It's always had extra pencils and a sharpener and all that. Okay, so voluntary, you get it. It has to be a voluntary action. You put yourself in that status. Involuntary, reflexive movements, convulsions, actions during unconsciousness, and then sleep behaviors, sleepwalking. You do something while you're sleepwalking. You gotta prove it. Have a doctor here. That's called an affirmative defense. But you have to prove the involuntary action. Any of these. Reflexive movements. I remember that I was walking, gosh, way back, maybe 1984. Okay, now I'm just an officer. Walking through a Sally port and this bastard, I couldn't stand him, another officer. Prejudiced to the hilt, always talking crap. They ended up firing him, that's how bad he was. He came up behind me, and this is in the Sally port, and grabbed me by the back, right around my throat. And he said he was joking, I thought he was full of crap. So I grabbed him by the elbow, and I flipped his ass over, and I was getting ready to punch him. All instinctive, it was reflexive. My partner grabbed me before I wish he went up, I would love to punch him. But it was reflexive. So if he would have broke his back, which he didn't, but if he would have broke his back, that's not my fault. Okay, that was instinctive. Can you follow that chain of thought? Instinctive. Nobody's gonna say this, I will. What about a firearm? Okay, you have your firearm, it's holstered, you're legal to carry it, it's licensed, and you're walking. And somebody comes up behind you, startles you, scares the hell out of you. You don't know who it is. You draw, before you know it, boom, you put a round in them. That fall under instinctive? Is that a good shoot or a bad shoot? It depends. And when I throw out these scenarios, guys, there is really no right or wrong answer. It always comes down to it depends. It really does. It's called totality of the circumstance. Everything's got to be mitigated. And then remember, it's going to get argued in front of a jury. The jury will ultimately decide if that action was involuntary or did the shooter know what they were doing. But you get the picture, right? It gets real difficult. Possession as actus reus. Let's see if they talk about constructive. No. Possession. The ability to exercise control over property or objects does not require physical custody, can be actual, direct physical, or there it is, constructive. Ability to exercise dominion or control. Let's talk about this first one. This happens when you're talking about large organizational crime. And we'll talk about a cartel. The main shot callers probably never leave their homes. They have all their minions doing the dirty work. Okay. They never saw the product. They probably never even saw the cash coming back. But yet, they have total control of the operation. So they're still guilty because it falls under constructive possession. All right. This also applies to your own home. You may have something in your home that's there illegally. Maybe it's in your room. You're hiding it from your parents. A bag of some kind of narcotic. But it's not on your person. Somebody snitched on you. We know you have prior use. We have a reliable source of information. We execute a warrant and we find it in your room. We'll charge you with possession of a controlled substance, even though it's never even on you, but you had control. Does that make sense? Yes? Get quiet on me. I know it's dark, you're getting comfortable. Okay, examples, and then there's some examples. Okay? Failure to act. This gets a little iffy here. Omission. The one that comes to mind is a lifeguard. I don't know what they're going to tell you. You can read the slide. But the lifeguard. They've sworn an oath to protect this stretch of the beach, even if it puts their own lives in peril. But to what degree? Okay, they still got to make that call. If the water's really rough and there's a risk of them not making it back, they can get away with not taking action. But if it's calm waters and there's somebody out there that this person, a jury, believes, a reasonable person would believe, the lifeguard could have acted and saved the life, but chose not to because they had just put some new spray can on themselves. They didn't want to wash it off. Just think. They could be held culpable for that crime because they failed to act. That's the omission part. Peace officers, it applies to them as well. Firefighters, anyone who has sworn an oath to protect and fails to act can be held liable. Doesn't happen very often, but it can happen. That's what the slide tells you. What else we got? Speech. Oh, yeah. Right? Constitutional right, First Amendment, right of speech. Right. Do I have the right to free speech? Yes or no? Come on.
Yes.
Yes, I have the right to free speech. Is it absolute? Hell no. Okay. So I'm standing up here telling people, let's riot, let's burn this place down, and I'm inciting violent behavior. I can't be charged. Okay, I can't be charged with a crime. You're in a crowded theater, and we're watching that movie Weapons that just came up. Okay, and somebody screams at the top of their lungs, "There's a bomb in here!" What are all these people gonna do? And they're gonna get the hell out of there, right? They're gonna make for those doors. They don't care who they run over. People are gonna get hurt. You're laughing. You think it's the funniest thing in the world. It's not funny, because you will be held liable for your actions. So So free speech is not absolute. There are conditions. And this kind of tells you some more of those thoughts, yeah.
Yelling fire in a theater is another one.
Where?
Yelling fire in a theater is an example.
That's what I just said.
Oh, you said a bomb.
Okay, fire, bomb, same thing. You get the idea, right?
Mm-hmm.
Okay. Okay, so let me see this one. 18-year-old convicted, involuntary manslaughter, encouraging her boyfriend to commit suicide through text messages. The court found she was virtually present during the commission of the crime. It's pretty serious. Now let's talk about the criminal mind. This is where it gets a little more tricky. The act is observable. You can see a cause and effect. But how do you determine a guilty mind? It's tricky. Mens rea literally means guilty mind. Refers to the specific mental state an individual must possess to be legally culpable for the outcome of an action. The model penal code, we talked about that last week, standardized 4 mental states that can be established for criminal liability, from least to most culpable. And you will see, this is the model penal code. If you remember, the model penal code does not apply to the states. It's only used for a reference. But I can pretty much assure you that every state has adopted these 4 state of mind. Purposeful, that must be the intent. Conscious, objective, to cause the result. I told my best friend I was gonna get even with that person for what they had done to me. I told my friend I was gonna stop the person, I was gonna watch them as they exited their home, and then I was gonna shoot them. I told them, I already bought the ammunition. I'm gonna use my dad's gun. I have a plan. We have a witness. They catch me at the scene of the crime. They know damn well that I intended to shoot, if not kill, but a reasonable person would believe if you shoot someone 2 or 3 times, they're gonna die. So whether or not this person died or not, it's either gonna be murdered or attempted. Knowing, awareness that results is practically certain. You know what's gonna happen when you strike that match to the gasoline you poured all over the face of that house. You know what the result's gonna be. It's reckless, conscious disregard, or substantial risk. Your negligence should have been aware of that risk. I only wanted to shoot at him. I didn't mean to hit him, he moved. Or I missed him, but I shot the neighbor. Because he went through the fence. And the neighbor was out there weeding, and I shot him. I didn't mean to. I was just wanting to scare this person. Doesn't matter. You're still culpable. The guilty mind. And this has to be proven in court. Types of intent. Specific, general, and transient. Specific, pretty self-explanatory. I wanted to commit a burglary. I went into that home. I took things that didn't belong to me, and I left. I knew exactly what I was doing. General intent. The actor intends to perform the act, but doesn't necessarily intend the specific consequences, like the shooting. I intended to scare this person. I even shot down and away. I didn't know a bullet could ricochet, but it did, and it hit a motorist as they were passing by. General intent. Transfer. Intent follows the act even when the victim is not the intended target. Bob shoots at Mary, but hits Jill. Bob's intent transfers to Jill. Shooting into a crowd, driving a car on the sidewalk. I intended to kill my ex-girlfriend and her new boyfriend, and I drove up onto the sidewalk. I didn't mean to hit the other 10 people. Never even saw them there. Transferred intent. Your actions resulted in these losses. Criminal negligence. Now it gets tricky. Failure to reasonably perceive risks of dangerous consequences. Negligence of such nature that's punishable by crime. And flagrant and reckless. The example I like on this one, I love traveling north, especially in cold weather. And I go visit my friend who lives in South Dakota in February. Everything's frozen solid, right? Snow everywhere. He knows I'm coming over to watch a football game. He thought it'd be real funny, instead of salting his walkway, that he watered it down. It looked like an ice rink, it was so smooth. So I go and I walk up and bang, land on my head, and I break my neck. Failure to reasonably perceive dangerous consequences. He thought it was gonna be funny. Never realized somebody could get seriously injured. Thank God I don't hang out with people that don't. But some people do. Some people do. Because of his actions, I can sue him. And he's gonna be held liable. He did that intentionally. Reckless, didn't care about my safety or others. Absolutely, meets the elements. For, if not a criminal liability, at least a civil case. Somebody getting sued. So don't do that. Okay, don't do, thinking practical jokes, prank somebody. I think there's shows about it, and I think it's the funniest thing in the world. Somebody could get hurt, so be careful. It's still funny, but be careful. Okay, strict liability. Statutory rape. No defense. It's triggered by the age of the defendant. I had a cadet in one of my academies. He had applied, and they were gonna hire him for a job somewhere in law enforcement. He filled out his background form, 30-something pages, if you ever get the opportunity to do that. Like 30-something pages of your background you gotta fill out. And they got to the point, have you ever committed a crime? And that's what he wanted to talk to me about. He says, well, technically, he did. Statutory rape. He was 18, his girlfriend was not quite 17. They engaged in sexual activity. Somebody found out, they filed a complaint, and he was arrested and booked. It sounds pretty bad. He ended up marrying that girl. They were still married, this was a while back. Had a few children, living happily ever after. Technically, it's a crime because of the statutory status. Okay, you get that part? Remember we talked a little bit about juveniles, like drinking and smoking. It's not a crime if you're legal, but if you're underage, then it becomes a crime. That's called a statutory crime. Selling alcohol to minor, drugs, safety, you get the rest of it. Justification. Protect public welfare, simplify enforcement, incentivize extreme caution, certain activities, causing harm in itself is considered blameworthy. So strict liability doesn't matter. It doesn't, intent, the motive, doesn't matter. All that matters is there's a law against it, black and white, and you broke that law. He did get the job, by the way. I wrote a nice letter for him, explaining what had happened. The girl's parents actually wrote something to support him. Good kid. As far as I know, he's still working somewhere. When statutes are silent on mens rea, what they're saying here, the law's vague. It doesn't specifically address these circumstances. So what they do is they fall back on common law. What have you done before? Review relevant case law, precedent. When we talk about stare decisis, what happened before under these circumstances? We can use that as a starting platform and then apply it to the current case, what we're working on now. Courts generally presume that criminal statutes include mens rea requirement unless legislature clearly indicates an intent to impose strict liability. Don't worry about that. That gets a little confusing. Just understand that if these circumstances are not clearly outlined in a statute somewhere, a court can rely on common law basis. Okay, other cases. Is that good? Concurrence, here it is. Timing is everything. Concurrence requires a criminal act to occur at the same time the actor possessed the intent. They gotta come together. Criminal mind without criminal act, no crime, mere thoughts. Harmful act without the requisite mental state, not a crime. mental state that forms after the act. Doesn't matter. They have to come together. I intend to cause this person harm. The person is present and vulnerable. I cause the harm. That's the concurrence part. Okay. What if, and this happens a lot in prisons where I was working, I get an officer, this inmate, he threatened to kill me. I want to write him up. I want to charge him because he threatened to kill me. So where was the inmate? Was he out in the yard? Oh no, he was in his cell. Was the door open? Oh no, the door is closed. So how the hell is he going to kill you? You're on this side of the door, he's on that side of the door. He can't kill you. But they always come crying, they want me to do something about it. I'll get another job. Tell McDonald's, I already get that out of here. No, they're gonna threaten, I've been threatened so many times, I can't tell you how many people wanted to kill me. Not so much anymore. Maybe when you get your grades, you want to kill me, but no, don't do it. In prison, they always want to kill us, the officers, they want to kill you. As long as you don't give them the opportunity, it's not a crime. But if they have the means, the ability, the intent, and the opportunity, then it's a crime. Say we're standing face to face. We're in a corridor somewhere. And this guy's threatened to beat my head in. Maybe he's holding a baseball bat. He's right on the yard. We're playing baseball. He's telling me he's going to use this bat. He's going to crush my skull in. Now is that a crime? It could be. Yeah, it could be. Depends on how good a writer I am. I'm a good writer. I'd get him if I wanted to. But yeah, because he has the means. He has the motive. He stated his intent. There's nothing keeping him from committing the act. Except me telling him, hey, just calm down, because I'm backing up. It's okay, and then look at the tower. I used to do that a lot. When I had my work crew, I'd tell the guys would get so mad at me. I'd be, you guys better chill up. Because I'm gonna hit the ground and I'm gonna point him. And that guy over there, the gunner would be waiting. I go, he's gonna start putting lead in your ass. He said, don't fall down, man, don't. They thought I would actually do it. And that was what kept them in line. I said, don't make me trip and fall, because somebody's gonna get shot. I'll start pointing at you guys. So anyway, concurrence, timing. It all has to come together. We're good there? Yeah. Concurrence examples. Non-concurrence. It's present and then something more complicated. Driver accidentally hits a pedestrian, then decides to leave the victim to die. The initial accident lacked the intent, the later intent to harm, that's where the criminal comes into place. It was an accident. Never saw that pedestrian. You made contact. You watched this individual. They're bleeding out. You did nothing to help them. You drove away. Or you just stood there. If you're in panic, a state of shock, that's different. But you just stood there, made a conscious decision not to call 911. And if you know first aid, try to help this individual. You did nothing. No concurrence. Concurrence is present. Driver intentionally hits pedestrian with intent to cause harm. The criminal acted in the pedestrian occurred simultaneously with the criminal intent. I intended to hit my ex-wife and her new boyfriend as they were going down the sidewalk. I drove up onto the sidewalk. I made contact, knocked them both out. That's a crime. That's a crime. A little more complex, person sets a trap intending to harm someone, but victim falls into it days later. Court may find the concurrence through continuing act doctrine. Yeah, I intended to harm him on this day. But 2 days later, I already had calmed down. I forgot to dismantle the trap. Then the intended target falls into the trap. It's a little more difficult, okay, because it was 2 days later, whatever, but after the fact. Concurrence, just the takeaway. I think I did a slide on takeaways. But the takeaway on this, you gotta get that the mens rea, the actus rea have to come together at the same time for it to be a crime. Somebody can still get hurt, but remember, we're talking about the crime. It has to be a crime. Brain science of mens rea. We're deep into the mind. Anybody studying biology that involves studying the mind or psychology, anything like that? No. Oh, you do. Okay, good. This maybe you'll follow then. Recent developments in neuroscience are challenging traditional concepts of what mens rea actually is. This is an ongoing argument. Brain imaging can reveal abnormalities affecting the decision-making ability of an individual. Neuroscience evidence increasingly used in criminal defenses. Questions about culpability when brain function is impaired, and potential for more individualized assessments due to a mental state. They're diving deep into the brain, and in future classes, I will delete this slide because you don't need to get that deep at this point. Just know that it's still being discussed whether or not the person had the mental state, the mental ability to understand the action. That's what they're arguing here. Not that the action actually occurred, but the mental state of the individual. Okay, classification of crimes, type and degree. Let's see, act-based classification. These crimes differentiated primarily by the nature of the criminal act, drug, theft, property. Intent crimes are like homicide, assault, and property crimes. You specifically intended to commit these actions on the right. The ones on the left, maybe you're driven by an addiction. Maybe you needed to feed that addiction, so you go and steal some things. So is it really that you intended to cause harm? Most of the times you're gonna find the only intent there was to satisfy that need for drugs, for narcotics, and not really theft. Okay. The system, and I did say this last week, is adversarial. We're talking about the courtroom now. Adversarial, at least in the United States, and I'd like to believe wholeheartedly, that everybody wants a win. We like to win. I know I do. I hate to lose. I want to win. So the legal system is set up with that idea in mind, that both sides want to win. The defense wants to get his defendant off, and the prosecution wants to put him behind bars. Okay, they have different objectives, different outcomes, and they're going to argue. They're going to do battle. They consider that adversarial. Advantages: it does protect innocent from wrongful conviction, ensures thorough examination of the evidence, prevents government overreach. Okay, disadvantages: difficulty proving mental state. In a criminal case, contrary to what you see on television, we don't care about motive. Really don't. I don't care why you did it. Don't have to prove why you did it. I just gotta prove you did it. Procedural rules may overshadow truth seeking. We don't care about the truth. That is a disadvantage. I told you last week, DA only cares what they can prove. They don't care if it's the truth. Knowingly, they will still seek prosecution if they know they can win the case. That's one of the problems. The burden of proof falls on the government to prove the concurrence of the criminal act with the criminal mind beyond a reasonable doubt. That's a heavy load to carry. It really is. Some people believe the courtroom is set in favor of the prosecution. It kind of is, and that's why. Because all of the burden is on the prosecution, not on the defense. Now, if the defense is going to argue an affirmative plea, then the burden shifts. An affirmative defense is like insanity. Yes, Your Honor, my client admits to committing the act. However, he's been off his rocker for some time now. Okay, then they go in and argue that case. So the burden switches. And there's other instances, but I just want to show you that the burden of proof can shift, okay, from prosecutor to defense. Presumption of innocence. This one, I don't know about. They'll tell you, the books tell you, the TV tells you, everybody tells you, you're innocent until proven guilty. If you've been charged with a crime, you know damn well it doesn't feel that way. It really doesn't. A friend of mine is back mid-90s. His name is Larry. Married a wonderful woman. He had kids, she had kids. She had custody, he didn't. She had a daughter. This girl was something else. She was about 13 at the time. Hanging out with another girl. Bad influence. Okay, so Larry's always complaining about her. Oh, this girl, she wants to go here, she wants to go there, she wants to do this. and her mom's letting her get away with this stuff, so he put his foot down. They had a little discussion and said, no more. You're not allowed to hang out with this person, you're not allowed to do this, that. Lay down the law. That little girl's friend said, you know, I used to have the same problem, and then I just cried rape. Told her mom, oh yeah, Larry's been touching me inappropriately, and Larry's been doing this, and he's been doing that. So she had to call the authorities. They put him on administrative leave. This guy said, I never did a damn thing. And she knew what she was doing because this other person was telling her what to do, calling the shots, a little bit older. It finally came out that it was all falsified. But during that time, it was a little over a year, some of his best friends cut him loose, wouldn't even talk to him. He was a child molester. And when Larry, I knew he wouldn't do something that stupid. I knew he was having troubles with this girl. Finally, she did tell the truth and say, no, she put me up to it. Larry never did anything. But during that time, do you think he felt innocent until proven guilty? Hell no. His friends cut him loose. We put him on in the mailroom. He wasn't even allowed inside the prison. His own friends cut him loose, wanted nothing to do with him. So yeah, you're presumed innocent until found guilty. Good luck with that one. Jury instructions, constitutional protections. The burden is on the prosecution, and we always have to follow evidentiary procedure. Evidence has to be collected a certain way, has to be presented a certain way. There is no hidden evidence or witnesses allowed, last minute testimony, or, Your Honor, I have this last piece of evidence I just got last night. No. Okay, no, it doesn't work that way. So we have to presume innocence, and we have to follow procedure. Recent developments, sleep medication cases, virtual, the one on the right, the virtual presence, boy, that's causing problems. And it will not end soon. Complex behaviors when not fully awake have raised questions about voluntariness of the criminal act. The court still has to determine how much culpability they're going to assess of the offender. We don't know, and it varies. Based on totality of the circumstances. Remember that phrase. Totality of the circumstance will dictate the outcome. Michelle Carter's case established that a person can be virtually present during the commission of a crime through text messaging. That was the kid suicide. Expands traditional notions of presence and participation of a crime. Facebook and all that other crap, the Instagrams, and I don't know what else is out there. There's so much social media. It could be good, but it could also be bad. And I'm glad that this person was held culpable for egging on this kid. He was vulnerable, and she's telling him, no, do it, kill yourself. There's evil people out there, guys. So be careful. Federal crime or criminal justice reform. Recent reform efforts address mens rea requirements. Let's see. Default state, clarity, let's take a look. Okay, this isn't really that critical to what we're doing in this class. Informational. And I tell you these things, you might have a question, because I don't write the questions, the publisher does. I edit them, and I try to focus on what I feel is important, but I may have missed something like this. I don't like asking you questions about this kind of stuff. Okay, but I apologize if a question does pop up. The other thing I don't like doing is having you try to memorize dates. If I see something that, in which year did this act take place? I'm never gonna let you do that. I don't care what year, just know that it passed sometime, look it up, if it's that important. So I don't like questioning you about specific dates. I don't like to trick you into, I don't do trick questions, guys, I just don't. So if you see something that doesn't look right, more of a tricky, bring it to my attention, I'll get rid of that question. I've got most of them. This falls in that arena. So we're not gonna really talk about this. This we will talk about, the key takeaways. Take a good look at that. Talked about the actus rea and the mens rea. Talked about how important it is, how critical it is to establish concurrence. You've gotta have mens rea, actus rea. You can have them individually, separately, not a crime. not a crime. It does not become a crime until you have concurrence. Please get that part. That's what you need to take away from this. You gotta have the concurrence for it to be a crime. And then strict liability, there is no mental state. You just gotta prove that it happened. And because it happened, the person who manufactured this device is culpable, responsible. Do you get what this chart is trying to tell you? Questions on this information, on the key takeaways? Teddy, you good? You get it, right? I think you do. Aaron, you good? Back here. Are you okay?
Yes.
Cynthia, you okay? Virginia, right? You're trying to ignore me, I see it. No, she's taking this, still. You get it, right? Okay, Logan, you get it too? Somewhat?
Well, the strict liability thing is kind of,
Confusing?
confusing a little bit, yeah.
Because we're trying to hold somebody culpable for a criminal act. Okay, criminal, not a civil. I told you at the beginning, strict liability usually falls under civil, but it could reach such a level of heinousness that the government gets involved. And you see this with manufacturing of, say, automobiles. Okay, the automobiles. The Broncos were rolling. Those Ford Broncos kept rolling. People are losing their lives. Okay, life loss. So not only are they gonna get sued civilly through some class action, but the government's gonna hold them liable via strict liability, because they manufactured these vehicles. They knew damn well, we proved they knew, they had a whistleblower, when they tested the vehicle, it had a tendency to roll at certain speeds and at certain turns. So they knew, but it was cheaper to just produce them and settle the lawsuits, and then make the corrections later, which they ended up doing. That's where the strict liability comes in a criminal case. Okay, focus, maybe that's it, because we're talking criminal. In a criminal case, strict liability does not matter if they intended to do it, they had the mental state to do it doesn't matter. Only matters is that it happened. And that's where the strict part comes into it. Whereas a criminal case, you have to have the actus rea and the mens rea and the concurrence. Just more you gotta prove. Hopefully that helps when you talk about it more if you need to.
Okay, for sure.
Any other questions, guys? About anything? Really? No, we're good. Everybody's happy? Okay, we're learning, we're picking up some new information, hopefully. Okay, if you have questions, please don't hesitate to contact me, ask. Otherwise, let me shut this recording off and get you on your way. We'll meet next week, same place, same time.